Or else, please take your seats. Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Guyana. The following matters have been fixed for the delivery of its reserved judgment this morning, and they are as follows. 1. CCJ Appeal number 7 of 2019 between Zulfikar Mustafa versus the Attorney General of Guyana and the Chairman of the Election Commission. Can we have the appearance in this matter, please?
Pleases you, my lad. Lads, Mr. Douglas Mendez leads me, Mr. Mohamir Anil Nandalal, Mr. Marcin Adil Sharma, Mr. C.B. Satram, instructed by Candace Barat for Zulfikar Mustafa.
Please, Your Honor. Attorney General appears in person in association with Mr. Ralph QC and Mr. Hal Gollop QC.
The second concept of matter, the consolidated judgments in CCJ Appeal number 9, 10, and 11 between Christopher Ram and the Attorney General of Guyana and the Leader of the Opposition and Joseph Harmon, between Bharat Jagdev and the Attorney General of Guyana and Dr. Barton Scotland and Joseph Harmon, between Charandas Prasad versus Compton Herbert Reed, Dr. Barton Scotland, the Attorney General of Guyana, Bharat Jagdev, and Joseph Harmon. Can we have the appearances for the court on these matters, please?
May it please Your Honours, Kamal Ram Grant for the appellant Christopher Ram.
May it please Your Honours, Sanjay acted in association with Mr. Stephen Singh and Ganesh Hira for the appellant Charandas Prasad.
May it please Your Honours, Neil Boston in association with Mr. Robert Corbin for Mr.
May it please Your Honours, in association with Mr. Rafi Khan, Senior Counsel for the respondent, Dr. Barton Scotland. May it please Your Honours, for the respondent, Mr. Harmon.
May it please Your Honours, the Attorney General appears in person in association with the Solicitor General, Mr. Nigel Hawk, Mr. Courtney, Ms. Iman Courtney, Senior Counsel.
May it please Your Honours, I appear on behalf of the added respondent, the Guyana Elections Commission.
Please, Jumalats, Mr. Mendez leads me, Davish Miraj, Mr. Mohamir Anil Nandalal, Mr. Marcin Adil Sharma, Mr. C.B. Satram, instructed by Ms. Candace Barat for the Leader of the Opposition, Mr. Barat, involved.
Yes, good morning, Council. This morning I would read summaries of the two sets of cases, and after I've read the second summary, we will then have a discussion about consequential matters. Before I read the first summary, which will be the Zulfikar matter, I just wish to place on record the court's deep appreciation to Ms. Misha Kelly, our Deputy Registrar, who is going to be soon leaving us. Ms. Kelly's, the title of her position is Deputy Registrar, but it is a little bit of a misnomer. She actually functions in the same way that a registrar functions in other courts, because our registrar is actually the CEO of the court. over the short time that she has been with us, Ms. Kelly has overseen, along with Mr. Hadial, the rollout of our courier software system and is an expert in that area. We are going to miss her very dearly. She has developed an enviable reputation among those whom she supervises, our Judicial Council, and the judges certainly will sorely miss her. So I wish to take this opportunity to wish her all the very best in the future. The case of Zulfikar Mustafa against the Attorney General and the Chairman of the Ghana Elections Commission. This case concerns the constitutionality of the appointment of Reverend Justice, retired, James Patterson, who was appointed on the 19th October 2017 by the President of the Republic as Chairman of the Ghana Elections Commission. The President made the appointment pursuant to the proviso of Article 161(2) of the Constitution. Mr. Mustafa, the appellant, complained that the process engaged by the President in appointing Justice Patterson was flawed. He asked the court to quash the appointment and to direct the President to choose one of the 18 persons who had been nominated by the Leader of the Opposition, Dr. Jagdeo, to that position of chairman. The Attorney General, on the other hand, has maintained that there was nothing wrong with the process and that Justice Patterson was properly appointed. Justice Patterson's appointment followed a series of written exchanges between the President and the Leader of the Opposition. These exchanges began in November 2016 and ran until October 2017. During that period, the Leader of the Opposition submitted 3 lists, each containing 6 nominees for the position of GCOM chairperson. The first list was rejected as being unacceptable within the meaning of the Constitution because, in the view of the President, the curriculum vitae of the nominees did not seem to conform to the requirements of the relevant constitutional provision. The second list was rejected by the President as he found it to be unacceptable within the meaning of the Constitution and also within the 4 walls of the criteria that he had set out in a statement of qualities of the chairman of GCOM, which statement he had submitted to the Leader of the Opposition. No specific explanation was given as to what made the list or the particular nominees named in it unacceptable. Prior to the submission of the third list, the government and the opposition issued a joint statement which provided, amongst other things, that the parties had met to consult, and I quote, on the way forward on the selection and appointment of the chairman. The parties also agreed that the chairman should be appointed without undue delay, unquote. The Leader of the Opposition submitted the third list, and the President, without providing explicit reasons, again disapproved this list as being unacceptable. The President then advised the Leader of the Opposition that he would have resort to the proviso, and Justice Patterson was then appointed. The decision unilaterally to appoint the chairman was justified on several bases. First, the President alluded to the discretion and power Article 161(2) granted to him. Reference was also made to the presidential immunity from court scrutiny under Article 182(1), which it was claimed empowered the President to act in his own deliberate judgment when exercising such discretion. Relying on those provisions, the President indicated that he had decided that it would not serve the public's interests to further delay the appointment of a chairman. The President also sought to rely on the July 2017 ruling of the High Court in Gaskin against the Attorney General, a case which had been decided after the second list had been rejected, but before the third had been provided. Before addressing the substantive issues in the case, the court considered certain preliminary objections made by the Attorney General. The court found that these objections had no merit and had been rightly overruled by the courts below. The court decided that the propriety of the chairman's appointment was a matter which could be inquired into because unless specifically ousted, the court has an inherent jurisdiction in matters relating to the interpretation of the Constitution. The court also held that it was its role authoritatively to settle what the Constitution means and whether some action taken by a constitutional actor is within or outside his or her constitutional remit. When a citizen raises legitimate questions that the appointment of the chairman of the Elections Commission may not have been in accordance with the Constitution, the court should not deny standing to such a person. Democracy and the rule of law are nourished by the posing of such questions and the court's answers to them. Mr. Mustafa, as a citizen, a registered voter, and a member of the National Assembly representing a non-governmental party, had sufficient interest to bring the application. The court considered that the essence of the case lay in the proper meaning of Article 161(2). To determine this meaning, the court looked at its drafting history. Under the 1980 Constitution, the Elections Commission chairman was appointed by the President in his own deliberate judgment from among persons who fulfilled certain defined eligibility criteria. This provision was modified in 1995 by Act No. 15 of 1995, which amended Article 161(2) and carved out a role in the appointment process for the Leader of the Opposition. This modified role of the Leader of the Opposition had been proposed by the Carter Center, which in 1990 had been invited by the then President Hoyt to observe the then upcoming elections. This proposal, which was known as the Carter Formula, provided for the submission by the opposition parties of a list of the names of 6 persons, from among whom the then President Hoyt would select a chairman. The Carter Formula was eventually incorporated into the 1995 Act, which amended Article 161. This amendment, however, came to an end by virtue of a clause limiting its operation up to a specified date, and so the unilateral appointment under the 1980 Constitution was revived. In 1999, a Constitutional Reform Commission recommended, amongst other things, that, and I quote, the chairman of the Electoral Commission should be full-time and should be selected on a consensual process, unquote, as provided for in the 1995 Act. This recommendation was adopted by the National Assembly and incorporated into the Constitution, Amendment Act No. 2 of 2000, with minor changes in the language. The court noted that the evolution of Article 161(2) had been characterized by a significant and deliberate shift from exclusivity and unilateralism on the part of the President to inclusion and consensualism as between the President and the Leader of the Opposition. The court examined Article 161(2) and noted that the first paragraph addresses in very specific terms the issue of the eligibility of candidates for the position of chairman of the Elections Commission. The Leader of the Opposition is required to submit to the President the names of 6 persons who satisfied the eligibility criteria, and the President is obliged to appoint one of the 6 nominees as the chairman. The article also provides that the listed persons must be, quote, not unacceptable, unquote, to the President, and that in arriving at the list, the Leader of the Opposition is obliged to meaningfully consult with any non-governmental political parties represented in the National Assembly. The court found that while it was clear what was meant by meaningful consultation, as that phrase is defined by Article 232 of the Constitution, it was not clear what process should be followed to accommodate the spirit of consensus that must prevail between the President and the Leader of the Opposition. The court decided that the most sensible approach to operationalizing the article was for the Leader of the Opposition and the President to communicate with each other in good faith and perhaps even meet to discuss eligible candidates for the position of chairman before a list is formally submitted. The aim of these discussions should be to agree the names of 6 persons who fit the stated eligibility requirements and who are not unacceptable to the President. In this regard, the court noted that the Constitution anticipates that the Leader of the Opposition and the President will conduct themselves in a reasonable and responsible manner, eschew partisanship, and seek the best interests of the Republic and the Guyanese people. The court was also of the view that the employment of the double negative, not unacceptable, signals that an onus is placed on the president not to find a nominee unacceptable merely because the nominee is not a choice the president would have himself made. By a majority, the court found that the president should only find a nominee unacceptable for some good reason on objective grounds. If a president were permitted capriciously or whimsically, without proffering a good reason, to reject eligible nominees, this would frustrate the proper working of the Constitution. It would defeat the intention behind the amendment to Article 161(2), and it would pave the way for unilateral presidential appointment. The court found that once the president and the leader of the opposition have hammered out a list of names not unacceptable to the president, the list, comprising those 6 persons, must then formally be submitted to the president by the leader of the opposition, and the president must then select a chairman from among those names. In the court's view, such an approach gives the president a role in the identification of the 6 names, but obviates the possibility that after the formal presentation of the list, the president could suggest that one or more of the names, or indeed the entire list, is unacceptable. In those circumstances, a unilateral appointment by the president, in keeping with the proviso to Article 161(2), can hardly be an option if the leader of the opposition demonstrates a willingness to engage in good faith the process outlined above. The court reviewed what transpired between 22nd November 2016 and 19th November 2017, and the court determined that the president was not entitled to lay down, as a precondition to considering a nominee, eligibility requirements that were additional to or at variance with those prescribed by the Constitution. The court emphasized, however, that nothing in its judgment was intended in the slightest degree to cast aspersions on Justice Patterson's competence and suitability for the position of chairman of GCOM. Nor was there any suggestion that His Excellency acted otherwise than in good faith. Accordingly, however, in view of the unfortunate process that was followed, in view of the imposition on the leader of the opposition of criteria that were not sanctioned by the Constitution, and in view of the absence of cogent reasons for deeming unacceptable the candidates and lists provided, the court concluded that the process that was followed in the appointment of Justice Patterson was flawed and in breach of Article 161(2). In this regard, the court overruled Gaskin to the extent that the judgment in that case was in contradiction with anything that was stated by the court in this case. Justice Anderson, in a separate concurring judgment, agreed that the process followed in Justice Patterson's appointment was fatally flawed and did not comport with the constitutional requirements. While Justice Anderson agreed that the finalization of the list of eligible nominees should be through a process of consultation and dialogue between the president and the leader of the opposition, he was unwilling to find that at this stage, to impute into Article 161(2), there was a requirement to give reasons. He was of the view that deciding on the probity of the reasons given by the president as to why a person on the list was unacceptable to him was not a task that the courts ought necessarily to invite or be eager to undertake. He also found that the court should be slow to impose constructs which exert Lilliputian constraints on the policy discourse undertaken by the Republic's political giants, unless and until such constructs and constraints cannot be constitutionally avoided, unquote. Justice Rajnath Lee, in a separate concurring judgment, considered the historical evolution of Article 161(2) and the President's duty to give reasons. Justice Rajnath Lee found that Article 161(2) contemplates a consensual process whereby opposition political parties in Guyana will participate in a meaningful way in the selection of the chairman of GCOM. Further, given the modern trend towards openness, fairness, and transparency, and the historical background of electoral reform in Guyana and the amendments to Article 161(2) of the Constitution, there was a duty on the President to give reasons for rejecting the list submitted by the Leader of the Opposition. The giving of reasons by the President will ensure transparency and accountability to the people, avoid unilateralism and arbitrariness, and engender public trust and confidence in the elections process. Having regard to the foregoing opinions and conclusions, the court intends to invite the parties to make submissions on the consequential orders that should be given by the court. And that invitation, we will discuss when and how it will be taken up. This is a summary of the judgment of the court in what I may refer to as the no confidence motion case. Article 106(6) of the Guyana Constitution states that the cabinet, including the president, is required to resign if the government is defeated by the majority vote of all the elected members of the National Assembly on a vote of confidence. Article 106(7) further mandates that an election be held within 3 months of the vote or within such longer period as determined by 2/3 of all elected members of the Assembly. On the 21st December 2018, the Leader of the Opposition moved a motion of no confidence in the government. All 65 members of the Assembly were present and they all voted. Mr. Sharandas Prasad, a government member, joined the 32 opposition members in voting for the motion, so that 33 members ultimately voted in favor of the motion and 32 voted against. Despite this, the government did not resign and no resolution was passed to prolong its continuance in office. Instead, litigation ensued. Mr. Compton Reed, a private citizen, sought a declaration that Mr. Prasad's vote on the no confidence motion was invalid because Mr. Prasad held dual citizenship at the time of his election to the Assembly in 2015, contrary to Article 155 of the Constitution. The Attorney General contended that the formula for achieving a majority of all elected members of the Assembly for the purpose of Article 106(6) was at least 1/2 of the members plus 1. Utilizing this formula, he argued that 34 votes were required to pass the motion. Another private citizen, Mr. Christopher Ram, sought declarations that the motion had been properly passed by the 33 votes cast in the Assembly and that national and regional elections were required to be held no later than 21st March 2019 in accordance with Article 106(7). Chief Justice Roxanne George found that a majority of all 65 members of the Assembly was 33 votes, as the formula required by Article 106(6) was simply one above the maximum number of potential opposers. She therefore held that the motion of no confidence had been validly passed. She further held that she had no jurisdiction to entertain the claim that Mr. Prasad's appointment was contrary to Article 155, as any challenge to his appointment had to be made within 28 days of his election to the Assembly, in accordance with the National Assembly Validity of Elections Act. Regardless, she held that Mr. Prasad's disqualification would not have invalidated his vote on the December 21st motion, as Article 165(2) of the Constitution preserved the validity of his participation in the Assembly's proceedings. The Court of Appeal unanimously upheld the Chief Justice's decision that the claim against Mr. Prasad's election could not be entertained and that his vote could not be invalidated. A majority, however, agreed with the Attorney General's 1/2+1 formula and found that the motion required 34 votes in order validly to be passed. Both findings of the Court of Appeal were appealed to this court. It was argued on behalf of the Attorney General, Mr. Reed, and Mr. Joseph Hammond, all lumped together and referred to as the respondents, that Article 106.6 did not apply to motions of no confidence. They highlighted the fact that the article in the Constitution used the phrase, and I quote, on a vote of confidence, unquote. And they submitted that there was a fundamental difference between a motion of confidence and a motion of no confidence. In particular, it was argued that only a member of the government could move motions of confidence, and that the article, that's Article 106, that article's requirement for the government to resign and for elections to be held did not apply to motions of no confidence. The court rejected these submissions. The court held that Article 106 gave effect to the fundamental principle of responsible or accountable government, a principle that required the government to resign when it no longer enjoyed the confidence of Parliament. Whether Article 106.6 used the term, quote, a motion of confidence, unquote, or, quote, a motion of no confidence, unquote, was unimportant, as these were mere linguistic differences denoting different sides of the same coin. There was nothing in Article 106 that prevented any member of the opposition from moving a motion of no confidence. Article 106.6 also did not hinge on the provisions of the anti-defection regime set out at Article 156. That regime was separate and distinct from the concept of responsible government and merely sought to prevent a member of the National Assembly from crossing the floor or, having been elected on a particular list, from disassociating himself or herself from that list and continuing in Parliament as an independent member. The court then went on to consider the majority needed to pass a motion of no confidence. The court decided that the requirement for a majority of all the elected members of the National Assembly referred to a majority of the total number of votes or seats in the Assembly, irrespective of the number of members who actually vote. In determining that majority, the court was of the opinion that the half plus one rule was not applicable. The court held that since the Assembly comprised an odd number of persons, that is 65, when all the members of the Assembly are present and vote, all that is necessary is to determine whether the motion has garnered, quote, a majority of all the elected members, unquote. Such a majority in the court's view was clearly at least 33 votes. The court then turned its focus to the issue of whether it had jurisdiction at this time to inquire into the issue of Mr. Prasad's disqualification from being a member of the National Assembly. The court found that historically disputes over the qualification of members to legislative assemblies were not triable by the courts, but were instead determined in the assemblies themselves. However, such matters eventually became entrusted to the courts. Justice Saunders pointed out that Article 163.1 has now vested in the High Court an exclusive jurisdiction to determine any question regarding the qualification of any person to be elected as a member of the National Assembly. The courts must exercise that jurisdiction within a particular framework established by the Constitution itself. Article 163.4 authorizes Parliament to make provision with respect to the circumstances and manner in which, and the conditions upon which, proceedings for the determination of any question arising under Article 163 may be instituted in the High Court. Parliament may also provide the consequences of the determination of any such question. The Constitution specifies that it was for Parliament and not the courts to lay down the practice and procedure in relation to the court's jurisdiction and powers in this regard. Although the Constitution gave the courts the exclusive jurisdiction to determine questions of the qualification of members of the National Assembly, the courts exercised that jurisdiction strictly in keeping with the provisions of Acts of Parliament. The relevant act in these circumstances was the National Assembly Validity of Elections Act, which required that a petition alleging that Mr. Prasad was disqualified from running for office be presented within 28 days after the results of the 2015 elections out of which the matter arose was published in the Gazette. The court emphasized that it had long been recognized that this election petition procedure was intended to be an exclusive one. The court held by a majority that the court had no jurisdiction to consider the question of the validity of a member's election to the Assembly by any other means. The majority emphasized that the court had no inherent jurisdiction to exercise in order to address the issue of disqualification of a member. The 28-day period having expired, the court therefore lacked jurisdiction to assess whether Mr. Prasad was disqualified at the time of his election. The court also held that there was no need to consider whether Mr. Prasad's seat ought to be declared vacant in accordance with Article 156(1)(d) of the Constitution, because Article 156(1)(d) applied to supervening events that caused a person to become disqualified while he or she was a member of the Assembly. And Mr. Prasad's disqualification clearly arose before he became a member. And two, Mr. Prasad had already been recalled and removed from the National Assembly on the 3rd of January 2019, the very day before these proceedings were initiated in the High Court. Having concluded that the court lacked jurisdiction to impeach Mr. Prasad's election, the court found that there was no real need to ascertain whether Article 165(2) preserved the validity of Mr. Prasad's vote on the motion. However, even if the court had jurisdiction to declare Mr. Prasad's election to the Assembly to be void from the outset, the court agreed with the courts below that Article 165(2) would have preserved the validity of his vote. Finally, the court rejected the submission that Mr. Prasad was absolutely required to vote against the motion of no confidence along with other members of the government list unless the party's whip granted permission for a so-called conscience vote. The court found that nothing in Article 156(3) or anywhere else in the Constitution prohibited Mr. Prasad from voting against the government on any particular measure. Such a vote may well cause the representative of his list to remove him from the Assembly, but his vote would still be valid. Having regard to all the findings above, the court held that the National Assembly properly passed a motion of no confidence in the government on the 21st December 2019, and that the provisions of Article 106(6) and 7 were accordingly triggered. In a separate concurring judgment, Justice Witt concurred fully with the judgment of the court. In relation to the meaning of the term a vote of confidence, he found that it was obvious from the legislative history of Article 106(6) that the amendments to the Constitution in 2000, by which this vote of confidence procedure was reintroduced into Guyana, sought to bring Guyana back from an authoritarian presidential regime to a more democratic one. It was within this framework that the provision ought to be interpreted. The restrictive approach suggested by the respondents as to the scope of Article 106 was also not consistent with the fundamental freedoms of conscience, expression, assembly, and association, in particular, the freedom to form or belong to political parties. A constitutional provision that sought to take away or limit these rights from members of the National Assembly, especially with respect to voting and supporting or not supporting the government, would need to be very clear and unambiguous for it to take effect. While acknowledging that Guyana had a hybrid legal system, Justice Witt was also not convinced that that system warranted the approach suggested by the respondents when compared to countries such as the United States, South Africa, the Netherlands, Suriname, Curacao, or France. In relation to Mr. Prasad's dual citizenship, Justice Witt found that the constitutional disqualification in Article 155 was not absolute, but one of limited scope. Moreover, statutes of limitation were well-known legal devices. Where there was a late discovery of a member's dual citizenship and the member refuses to vacate his seat, no legal consequences will ensue unless and until someone properly petitions the High Court in accordance with Section 43 of the National Assembly Validity of Elections Act to have the court declare that seat vacant. Justice Witt agreed that this situation did not occur in this case. Lastly, Justice Witt considered the reasons why the anti-defection and recall procedures in Article 156(3) were introduced. He found that none of the three grounds mentioned in the article had anything to do with voting in the National Assembly, and that the whole idea of the provision was to prevent members belonging to a list from, quote, stealing, unquote, their seats from their party. The possibility of recall may help to discourage, although not to prevent, members from voting against the list, but this was not the main reason for the provision. Justice Anderson, in a concurring judgment, also agreed with the other members of the court that Article 106.6 and 7 had been triggered. However, he noted that there may be merit in the consideration by those responsible for proposing constitutional amendments of the wording of Article 106.6, as he was far from sanguine that the Constitution was unambiguous on the issue of motions of no confidence. He expressed sympathy with the respondent's submission that the manifest purpose of the anti-defection provisions in Article 156.3 was to prevent a member from voting against his or her list, so as to ensure continuity and stability in the government. Application of Article 156.3 in this way did not necessarily render Articles 106.6 and 106.7 redundant, nor did it make parliamentary debates sterile or farcical. Nevertheless, Justice Anderson, drawing attention to the report of the Constitution Reform Commission to the National Assembly, which anticipated defeat and resignation of the government on a vote of confidence, and noting the fact that nothing in the Constitution prevented the leader of the opposition from moving such a motion, he concluded that motions of no confidence were allowed. He said that the court could not be expected to fashion the fundamental constitutional principles argued for by the respondents, and could effect fixed parliamentary terms from the mere imputations attributable to Articles 106.6 and 156.3. Justice Anderson was also of the view that the passage of the 28-day period specified in the National Assembly Validity of Elections Act will not always render the contested election unassailable. Such an inflexible rule, in his opinion, could lead to absurd and preposterous results. He considered that the circumstances in which a court was entitled to disregard the procedures and timelines specified in the election legislation in favor of upholding the fundamental tenets of the Constitution regarding eligibility to sit in Parliament were not entirely clear and required further thought. But he was of the opinion that one circumstance where this extraordinary jurisdiction may be warranted is where parliamentary membership was obtained by intentional and fraudulent means, as it would be an unacceptable affront to the Constitution to give its protection to a person who knowingly and fraudulently embezzled his or her way into Parliament, knowing full well that he or she was not qualified to sit as a parliamentarian. In the present proceedings, he did not find any clear allegations made or proof provided that Mr. Prasad knowingly and fraudulently deceived the people of Guyana and the Parliament in his election to the National Assembly. Accordingly, he agreed that the failure to challenge Mr. Prasad's eligibility to sit within the time specified in the election legislation rendered the challenge unsustainable. In another concurring judgment, Justice Rajnathli also expressed her agreement with the President's judgment. She, however, added some remarks on the system of proportional representation that existed in Guyana and the impact, if any, that that system had on the issue of whether Mr. Prasad's vote violated Article 156.3 of the Constitution. In her view, the key question that arose was whether, not having declared in writing in advance that he did not support the list from which his name was extracted, Mr. Prasad could validly vote on a no-confidence motion against that list. In other words, whether it was the intention of the framers of the Constitution that such a vote as that of Mr. Prasad's on the 21st December 2018 should be disqualified. Mr. Rajnathli found that there was nothing in Article 156.3 or in any provision of the Constitution that led to the conclusion that the framers of the Constitution had such an intention. In her view, there would have to be an express provision in the Constitution that any vote by a member against the list from which his name was extracted was disqualified. The argument that it was implicit from the provisions of Article 156.3 and from the system of proportional representation that the framers intended this effect could not, in her view, be sustained. Such a drastic consequence would have required an express provision within the Constitution itself. The member who voted against his list no doubt risked paying the ultimate political price and could be recalled in accordance with the provisions of the Constitution. Justice Razali therefore found that there was nothing which prevented Mr. Prasad from voting in favor of the no confidence motion. She agreed that the National Assembly validly passed the motion of no confidence and that the provisions of Article 106, 6, and 7 of the Constitution had been triggered. She urged all to bear in mind, as the court awaited further submissions, that the rule of law was an important guiding constitutional principle of a sovereign democratic state like Guyana. That was a summary of the opinions of the judgment of the court and the respective opinions that were given. Copies of the judgment would be delivered to the parties, and the two judgments will be placed on the court's website during the course of this morning. Now, we had said during the hearing that we would afford counsel an opportunity to address the court on, in particular, the consequential orders that the court should make in relation to the conclusion of the court on the Zulfikar matter. We proposed that we have between now and the 24th, the parties engage with each other, and that on the 24th, we will hear submissions from the parties, or we would hear from the parties on that issue of the consequential relief. I'm just being reminded to specifically indicate that the reading of the summaries is not intended to be a substitute for the reasoning of the court. The official reasoning of the court is to be found, of course, in the formal judgment, and that the summaries that I read are simply an attempt informally to summarize what is contained in the judgments. And those summaries, or anything that I said in reading those summaries, should not be taken or used in any consideration of the court's reasons. So, counsel, I need to know about your availability on June the 24th. I'm further reminded to point out that, well, and it would have been made clear, I believe, that Justice Rajnath Lee fully, she wrote an opinion in each of the cases, but that Justice Witt, who is not here with us, Justice Hayton, who is not here with us, fully concurs in the majority judgments which were delivered and has signed those judgments. So I need to know about the availability of counsel on the 24th of June for us to discuss the consequential orders in each of the two matters in which judgment was given.
Available, Your Honor, Sanjeev Dastan.
Commander Akran available, sir.
Yes.
It is convenient, yes.
Well, let's ask this question. Is it inconvenient to any party? Good. So on the 24th. Yes, Mr.
It is embarrassing to me, Your Honours, in that I'm committed to the Court of Appeal in Trinidad and Tobago, but I shall try to make some arrangement.
I would really appreciate that, sir. So we will. Yeah. Yes.
Came on coordinate for the Attorney General of Guyana. Now, so far as the date is concerned, we will make ourselves available. But I have one question for the court guidance. Is it that the court wishes to make a correction without any further evidence with respect to the consequence of the court's decision? And I'm speaking specifically with respect to the position of the TCOM.
The court did not propose to hear any further evidence. The court simply wished to hear from you whether there was any agreement among yourselves on whether on the orders that should be made by the court. The findings of the court are final, determinative, and it's simply a question now of consequential orders. And if between now and the 24th there is no concurrence on that issue, then we would have to find a way where, in fact, I didn't want to go there because I'm hoping that on the 24th you will come back and tell us that all sides have agreed on these consequences that will follow, and the court will order accordingly. So let's just stick to that point at this point in time. But you would see in the judgments of the court that there are clear findings made. The Constitution sets out, in some cases, consequences that must follow. And in the case in particular of the Guyana Elections Commission chairperson, we would like to hear from you, in particular in relation to that one, on what formal orders you might agree on, if you can agree, the court should make, and we'll take it from there.
Your Honor, can I make one suggestion with respect to the no confidence motion cases? And that is that for want of a better word, the appellants propose or put up the draft of what the consequential order should look like for review by the respondents, so that we, rather than us, both sides putting up orders.
Well, we wanted to take ourselves out of that process. So we encourage you to engage with each other. And on the 24th, if you can present us with some consensus, then if we find that that consensus is something that we can lend our imprimatur to, then we would be happy to do so. So that I didn't see it as a process of somebody putting up an order which is going to be shared with the court and there'll be back and forth involved in the court. That's something between now and the 24th, which the parties can and should do among themselves.
We are hoping for a happy marriage between principle and practicality.
So, in the absence of anything further, well, there's also the question which has not been addressed at all of costs. And that also can be discussed on the 24th. And perhaps even before, that can be an issue which both sides can talk among themselves in relation to as well. So the court will adjourn until the 24th at actually on the 24th we have a case in the morning, so we had scheduled this for the afternoon. So this would be 2 o'clock or 2:30? 2 o'clock. At 2 o'clock. We would set this matter down for hearing on the 24th at 2 o'clock Eastern Caribbean time, which I believe is 12 o'clock if you remain in Belize, Mr. Courtney.
2 o'clock.
Yes, Your Honor.
Yes.
But